Diane Abbott just walked into the House of Commons and absolutely demolished David Lammy, using his own boss's words against him. And honestly, it was glorious. We're talking about a masterclass in political judo, where she took Keir Starmer's own writing from 1992 and used it to smack down his Justice Secretary's plans to limit jury trials. The irony is so thick, you could spread it on toast. But before we proceed, please don't forget to hit the subscribe button for more updates on the UK political insight. Thank you. Let me set this up for you, because the context here is absolutely crucial. David Lammy, the Justice Secretary, has just announced a pretty massive overhaul of Britain's court system. And when I say massive, I mean the kind of change that makes constitutional lawyers break out in hives. He's basically saying that jury trials, that fundamental cornerstone of British justice that we've had for centuries, are going to be reserved only for the really serious stuff. Murder, rape, the big crimes. Everything else? Magistrates can handle it if the likely sentence is 3 years or less. Now, Lammy's justification for this is actually pretty straightforward. The court backlog is absolutely horrendous. We're talking years-long waits for trials, victims waiting literal years for justice. In London, if someone's raped today, their trial might not happen until 2028 or 2029. That's not a justice system, that's a justice suggestion. So from his perspective, cutting down on jury trials means cases move faster, victims get justice sooner, everyone wins. Simple, right? Except it's never that simple. Because what Lammy's proposing isn't just a technical tweak to how courts operate. It's a fundamental shift in who gets to decide your fate if you're accused of a crime. Jury of your peers versus professional magistrates. And that's not just a procedural difference. That's a philosophical one about the relationship between citizens and the state. Which is where Diane Abbott comes in like a wrecking ball made of well-researched quotes and righteous indignation. Because Abbott's been in Parliament longer than some MPs have been alive. She's the longest continuously serving female MP in the House, and she knows how to land a political punch. And the punch she threw today? Absolutely brutal. She stood up in the comments and started by acknowledging that everyone's concerned about victims, particularly women and girls facing violence. Smart move. Establish common ground, show you care about the same things as the person you're about to eviscerate. Classic debating technique. But then she pivoted. The entire House is also concerned about the many women who will undoubtedly suffer miscarriages of justice if the right to trial by jury is curtailed. Boom. She's not just opposing this for abstract legal reasons. She's talking about real women who will be affected by this change. Women who might be wrongly convicted because they don't get a jury trial. And here's where it gets absolutely delicious. Abbott pulls out a quote from a lawyer who wrote that the right to trial by jury is crucial to the balance between state power and individual freedom, and that restricting it creates a dangerous imbalance. Powerful words, right? Really drives the point home about why jury trials matter. Then she drops the hammer. That lawyer? Keir Starmer, current Prime Minister, who wrote those exact words in Socialist Lawyer magazine back in 1992. The same Keir Starmer whose government is now proposing to limit jury trials. The same Keir Starmer who 30-odd years ago was apparently very concerned about this exact issue. The level of political shade in that moment is off the charts. It's like finding someone's old social media posts where they said the exact opposite of what they're doing now, except this is the Prime Minister and it's about fundamental rights. Abbott basically said, "Your own boss agrees with me, not you," using his own published words. That's not just winning an argument, that's winning it with style points. And you can almost hear the collective intake of breath in the Commons when she said it. Because calling out hypocrisy is one thing, but doing it with actual documentary evidence from the Prime Minister's own pen? That's next level. That's the kind of political move that gets talked about in Westminster bars for months. Abbott then directly challenged Lammy. How can the Chancellor stand up and propose a limitation of the right to trial by jury when he knows perfectly well the category of defendant who will suffer the ill effects of that act? She's not asking a rhetorical question there. She's genuinely putting Lammy on the spot in front of the whole house with the PM's own words hanging in the air like an accusation. Now, Lammy had to respond to this, and let's be honest, he was in an impossible position. How do you defend a policy when your boss wrote the perfect critique of it 30 decades ago? His response was to lean hard into the practical realities. Women affected by criminal cases. Many crimes committed by women dealt with by magistrates already. Victims waiting years for trials. He painted a picture of a broken system that needs fixing now, not theoretical discussions about constitutional principles. And here's the thing, Lammy's not wrong about the practical problems. The court backlog is genuinely terrible. Victims are genuinely suffering. The system is genuinely broken. His argument is essentially, yes, jury trials are important, but so is actually getting trials to happen at a reasonable speed. It's utilitarianism versus principle, and both sides have valid points. But Abbott's counter to that is also powerful, because fast justice isn't real justice if it leads to more wrongful convictions. And there's legitimate concern that magistrates, who are either trained legal professionals or lay volunteers, might not provide the same protection against wrongful conviction as a jury of 12 random citizens. Juries can be unpredictable, can refuse to convict even when the evidence technically supports it, can show mercy in ways professional judges might not. There's also a class element to this that Abbott is clearly aware of. Who's more likely to end up in magistrate's court versus jury trial? Who has the resources to fight for their rights? Who understands the system well enough to navigate it? These aren't neutral, technical questions. They're questions about justice and equality. What makes this row particularly spicy is the personnel involved. Diane Abbott was elected as a Labour MP last year, but has since had the whip removed, making her an independent. There's history there. Years of tension between Abbott and the Labour leadership. So when she stands up to challenge Labour ministers using Labour principles against them, it's not just about this specific policy. It's about competing visions of what Labour should stand for. And using Starmer's own words from his radical lawyer days, that's pointed. Because Starmer has spent years trying to shed his lefty past, present himself as a moderate, serious, electable leader. Having his own socialist magazine articles quoted back to him in Parliament is exactly the kind of thing he'd rather avoid. It reminds everyone that he used to hold much more radical positions, which is awkward when you're trying to govern as a centrist. The irony of the situation is palpable. Keir Starmer, former director of public prosecutions, someone who spent his entire career in the criminal justice system, once wrote passionately about protecting jury trials. Now his government is limiting them. That's either pragmatic evolution or rank hypocrisy, depending on your perspective. And Abbott is very clearly saying it's the latter. Lammy's defense about women waiting until 2028 for rape trials is emotionally powerful, and it puts Abbott in a difficult position, because how do you argue against getting justice for rape victims faster? You can't really. But Abbott's point is that creating a two-tiered justice system where some people get proper trials and others get fast-tracked through magistrates' courts isn't the solution. Fix the backlog properly, don't shortcut fundamental rights. The broader context here is that Labour's facing criticism from multiple directions about being too authoritarian, too willing to restrict freedoms in the name of efficiency or security. Limiting jury trials fits into that narrative, whether fairly or not, and having voices like Abbott's from within the traditional labor movement pushing back against those criticisms gives those criticisms more weight. What's fascinating is watching the government try to position this as progressive. Lammy specifically mentioned women defendants, women victims, trying to frame this as actually protecting vulnerable people. It's savvy politics, don't let your opponents own the moral high ground. But Abbott is not buying it, and she's got the receipts to prove why. The technical details of what Lammy is proposing matter too. Indictable-only offenses like murder and rape still get jury trials. Either way offenses, which can be tried in either magistrates or crown court, only get juries if the likely sentence exceeds 3 years. That means a lot of crimes that currently get jury trials won't anymore. Theft, fraud, assault, drug offenses, all potentially losing the right to jury trial depending on sentencing expectations. And who decides what the likely sentence is before trial? The very system that's prosecuting you. See the problem? You're asking the state to decide whether you get protection from the state's power. That's the imbalance Starmer wrote about in 1992, and it's the imbalance Abbott is warning about now. The politics of this are going to rumble on because it touches too many nerves. Civil liberties campaigners are furious. Barristers are concerned. Victims groups are split between wanting faster justice and wanting proper justice. And the opposition's going to have an absolute field day with this, especially armed with Starmer's own words contradicting his government's policy. What today showed is that Diane Abbott, stripped of the labor whip or not, is still an absolutely formidable parliamentary performer. She knew exactly which quote to use, exactly when to deploy it, and exactly how to frame it for maximum impact. That's decades of experience showing through. Whether you agree with her or not, you have to respect the craftsmanship of that intervention. It's one thing to oppose a policy. It's another thing entirely